Right, okay, it looks like we probably have everybody who is going to join us now with us. That's great. As you will see from the slide as you dialed in, today's webinar is going to focus on an introduction to divorce. Charlotte and I are just going to work through some key points that you need to bear in mind when you are considering an application for divorce. Today's webinar is the first family webinar in a series of webinars that Goldsmiths Chambers is hosting this month. The aim of the webinars and the series as a whole is to deal with some of the legal issues that COVID-19 has thrown up and to give training in areas which we feel there's likely to be an increase in work following the COVID-19 restrictions and general problems that have been encountered. I'd like just to start by echoing what was said yesterday by our head of chambers, Anthony Metzer QC, that we hope that you will find this seminar and the other seminars in the series to be of benefit and of interest to you. As I said, today's webinar is intended to be a brief introduction to divorce. It's intended to be a short webinar lasting about 25 minutes with a few minutes at the end for any questions. We will circulate a handout which covers this topic in more detail. Can I note at this stage that this webinar is being recorded, so we ask that you make sure that your microphones are on mute so that we don't have any inadvertent feedback or background noise. Both the recording of this webinar and the handout will be made available on the Goldsmiths Chambers website if you need to refer back to them in the future. As I said, there'll be time at the end of the webinar today to ask any questions. You can use the Q&A button, which will be at the bottom of your screen, to post any questions, and we'll have a look at questions that come in towards the end. The seminar today has been divided largely into two parts. The first I'll deal with, and that looks at the mechanics of the application and making the application. And then Charlotte will talk about the more substantive considerations that you'll need to have in mind when you are making an application. So what does the divorce process involve? It largely involves 4 key steps. I'll refer to the parties in the way that they would ordinarily be referred to in the process. So the petitioner is the person making the application, and the respondent is the respondent's spouse, and in cases of adultery, can be the individual who has been identified as the person the other spouse has potentially committed the adultery with, so a co-respondent, if you will. The 4 main steps in the divorce process are, first and foremost, the making of the application itself. Once the application has been made, the respondent will be given an opportunity to respond to the application, either by way of an acknowledgement of service, and that, in cases where the application is not going to be disputed, is sufficient for the next step to then be taken. In cases where the respondent has indicated an intention to dispute the divorce, it will be necessary to file, for that respondent to file a reply, otherwise known as an answer, to the divorce application, so that the court can make appropriate directions. Once the respondent has been given an opportunity to respond to the application, either by way of an acknowledgement of service or by way of a more full answer to the divorce, the next step in the process is the application and pronouncement of the decree nisi. Once the decree nisi has been pronounced, then it's the parties' opportunities after a delay to then make an application for the pronouncement of the decree absolute. Charlotte will break this down into more detail in terms of the distinction between the two, but sufficient for now to say that the marriage doesn't end at the decree nisi stage, it's only ended at the decree absolute stage within the process. So how long does a divorce take? Well, an uncontested divorce takes on average between 4 and 6 months. That was the indication before COVID-19, and I think it's fair to say that all areas are going to be affected by an ongoing and increasing backlog in the courts, and also just the reduction in court staff who are able to process applications. So certainly expect it to take a bit longer while we're coming out of the COVID-19 health crisis. Naturally, contested divorces are going to take much longer because the court is going to have to list those contested divorces for appropriate directions and then hearings to determine the issues that have been identified within the application process itself. Whilst a terrifying concept for some, there may be some reassurance in noting that actually a contested divorce is relatively uncommon. Normally there's less than 1% of divorces actually end up being a contested divorce. So they are few and far between in terms of the general nature of divorces and how the process follows through. So who can apply for a divorce? To be able to get divorced in the UK, you'll need to be able to show, as the petitioner, 4 key points, and all 4 of them need to be shown. The first is that the parties have been married for over a year. The second is that the marriage is legally recognised in the UK. Some consideration will need to be given to this, in particular where parties have got married abroad, either destination weddings or otherwise. So bear that in mind if that does come up when you are speaking to your clients or otherwise. The third consideration is that the UK needs to be the permanent home either of the petitioner, so that's the person making the application, or the respondent. Finally, the petitioner will need to be able to show that the relationship of marriage has permanently broken down. So it's all 4 of those points need to be shown before you'll be able to apply for a divorce in the UK. Well, how do you apply for a divorce? The divorce application can be made both on paper or it can be made online. To make the application on paper, you need to use Form D8, and to make the application online, you can follow the appropriate link using the .gov website. It's worth noting, though, that if an application is made on paper, it takes approximately a month for the court to process that application. If the application is made online, it takes approximately 10 days. I say that as indications that have been given again before the COVID-19 health crisis, so expect delays either way, irrespective of whether you're making it on paper or online. The application itself will need to be accompanied by the marriage certificate, a reconciliation statement where there is a solicitor acting. If there's no solicitor acting, the reconciliation statement is not required. And then the court fee or a fee exempt form. The current cost of a divorce application is £550. Updated fee guidance can always be found in the Form EX50. So just look at that again before you make the application to be sure that you have the right fee. If you're making the application on paper, you'll need to ensure that you've provided sufficient copies of the application so that it can be served on all the parties. You'll need to bear in mind that if this is a case where adultery is being raised as one of the grounds, you'll need to ensure that sufficient copies have been provided so that all co-respondents can be provided with a copy of the application. So that covers all of the mechanics of divorce. I'm going to hand over to Charlotte so that she can discuss grounds, separation and timing more generally.
Thanks, Shirin. So the first thing in terms of what you need to establish with the client, if you have a client who is seeking a divorce as petitioner, is the date of separation. Now, for some parties, that's going to be very straightforward because that is going to be marked by the day that one of the parties left the family home. However, that's not always the case, and later on I will come on to talk about circumstances where parties can continue to live together but actually still be separated. Now, the date of separation is different from the date the application for divorce is made. And the date of separation is extremely important because it can have tax implications and it can also have an impact on what assets are deemed to be matrimonial and what assets are deemed non-matrimonial, which is important when it comes to the financial settlement at the end of any relationship. And there's also a risk that the date of separation can affect pensions. So it's important to establish the right date of separation with the petitioner and to make sure that that date is justified. So what are the grounds for divorce? Well, they're actually known as facts, and there are 5 possible grounds or facts for a divorce, and they are unreasonable behaviour, adultery, desertion, separation for at least 2 years, and separation for at least 5 years. And a petitioner should rely on at least one of those facts. Now let's take each of those in turn, starting with the most commonly used fact, which is unreasonable behaviour. And in order to rely on unreasonable behaviour, the petitioner must provide examples of behaviour that show it is unreasonable for them to continue to live and be married to their spouse. Now, there isn't a defined set of behaviours that are likely to be found unreasonable. However, it's things such as physical abuse, psychological abuse, financial abuse or hardship caused by the behaviour of another party in a marriage, mental abuse, and also things like drunkenness or drug taking or similar serious unacceptable behaviour. Now, the examples that you give need to be specific, and they need to be fairly up to date. This can't be something that's happened 5 or 10 years ago and then no action's been taken. And you may well be aware of the case of Owens and Owens, which is a fairly recent Supreme Court case where a divorce was not granted on the grounds of unreasonable behaviour because it was found that the grounds cited were not serious enough. Grounds cannot be trivial or trifling. So the second ground that can be relied on is the ground or fact of adultery. And the petitioner will have to say that the spouse had sexual intercourse with someone else of the opposite sex. It should be noted that homosexual relationships are insufficient for the ground of adultery, although they could well be used under the unreasonable behaviour heading or fact, depending on when they occurred. Now, adultery cannot be given as a fact if the parties continue to live together as a couple for more than 6 months after they found out about it. So it requires fairly swift action. So the fact of desertion is the third fact that can be relied on. And that is where the petitioner's spouse has left them for at least 2 years prior to the application for divorce. And the petitioner can still rely on that fact if the parties have lived together for a total of 6 months in this period, but that 6-month period will not count towards the 2 years. So the fourth ground is separation for at least 2 years. And the petitioner can apply for a divorce if they have been separated for 2 years prior to applying for the divorce. The key point with a 2-year separation is that both parties must agree to it. There must be written consent to that agreement. Now, it doesn't require that parties are living separately in different houses, but they must not be living together as a couple. Now, the fifth fact or ground is separation for 5 years, and there needs to be no consent for this. So it's often used by parties where they don't want to use unreasonable behaviour, but they also can't get the consent to divorce their spouse within the 2 years. So what happens, as is sometimes the case, if parties have lived together after they've separated? Now, there may be many reasons why parties decide, potentially for financial reasons, for work-related reasons, or for family-related reasons, that they have to continue to live together in the matrimonial home, notwithstanding that they're no longer in a relationship. Now, that in itself is not a bar to a ground for divorce. However, it must be the case that the parties are living separate lives. And that would need to be evidenced, for example, by not spending time together, even though they're living in the same property, maybe not eating together, using kitchen at different times to prepare their food, and not sleeping together. There have been cases where, notwithstanding the parties feel that they're separated, because they're living in the same home and because perhaps they are sharing childcare, sharing meals, that the courts have said, actually, then you're not separated. Now, there may also be occasions where parties have attempted to unsuccessfully reconcile, and that in itself isn't an issue as long as these periods of reconciliation do not total more than 6 months in a 2-year period, the parties can still be viewed as being separated by the courts. So moving on, what's the difference between a decree nisi and a decree absolute? Well, the decree nisi, in brief, shows that the court accepts the petitioner's grounds for divorce, but at the point that the decree nisi is pronounced, the parties are still married. The decree absolute is the document that ends the marriage, and it's only after the decree absolute that you can go on and, if you wish to, remarry. So is there any reason for delaying application for a decree absolute? Well, there are some reasons that you may want to advise your client to delay. Although a decree absolute can be granted without a financial settlement, because the divorce process and the financial settlement are completely separate procedures, there are scenarios where it is going to be in the party's best interest to try and arrange a financial settlement at the same time as the divorce proceedings and before the decree absolute. This is because entitlement to certain assets of the marriage can be affected if the parties are already divorced. So, for example, some trust be transferred to a spouse. Once the parties are divorced and there is a decree absolute in place, those funds cannot be transferred. And it is important to always look closely at any pension funds or trust funds to see what the terms are, so that you can properly advise your client as to what's in their best interests. Equally, if assets are transferred when parties are still married, so prior to the decree absolute, they may be able to avoid certain tax charges that will be attracted to the transfer if they did the same transfer after the granting of the decree absolute. So those are really considerations for your client for the financial aspects of the end of their relationship and making sure that they get the best financial settlement that they may want. Now, of course, it's the case that parties often do want to get a decree absolute as quickly as possible so they can move on with their lives, but it's important that clients appreciate that they can't fully often move on until there have been settlement of the financial assets, regardless of whether the decree absolute has been pronounced, and therefore it is important and incumbent upon us as their lawyers to ensure that they get the best financial settlement, and they do that at the best possible time for them, given their circumstances. So that's the presentation that we are giving you today, and we're happy to answer any questions for a few minutes. I think the best thing, Sharon, is for any participants to type in the chat, and we can field any answers that we have.
Yeah, so chat or the Q&A, either, whichever people find easier to use, and we'll have a look through and answer any questions that come up.
So one of the questions is, what is the duration to absolute? So in order to obtain a decree absolute, the petitioner needs to wait 6 weeks and 1 day, which is 43 days in total, from the granting of the decree nisi. The respondent party can also apply for the decree absolute if the petitioner doesn't apply themselves, but the respondent will have to wait an additional 3 months on top of the 43 days. And it's also worth noting that you should really apply, unless you have good reason not to, for the decree absolute within 12 months of the granting of the decree nisi. Otherwise, you'll need to explain your reasons for the delay to the court.
Yeah. I can see a question here. Can financial matters start at the same time as the divorce petition is filed? And the answer is yes. If you look at the application itself, there is a box to say, yes, I intend to raise a financial remedies application at the same time, and the court will then take that into consideration. Charlotte, just following on from one of your points that you raised, how long should parties not be sleeping in the same bed if living together? Well, the question really, if you're evidencing separation, the separation is better evidence and probably best evidence where the parties are not sleeping in the same bed. That's probably going to be a very influential factor in the court's determination of to when the date of separation is deemed to have taken place, particularly where there is a dispute between the parties as to when that separation date takes place.
I think you'd have to have really good reason for justifying why the parties were still sleeping in the same bed. Ultimately, it comes down to the circumstances that your client finds himself in, but I think they wouldn't be sharing a bed.
There is a question, how many incidents are required to mention a statement of case on the basis of unreasonable behaviour? Well, it's a balancing act, really. You need to be able to evidence a sufficient degree of the breakdown of that relationship. You need to also be able to provide sufficient evidence for the basis on which you are claiming the ground which you've selected. I assume in this case it's probably unreasonable behaviour, but equally, and I think solicitors will share this concern, that where you are making an application on the basis of an unreasonable behaviour of a spouse, the difficulty is if you throw too much mud at the wall, so to speak, you end up in a very, very contested, very acrimonious divorce, which could otherwise possibly have been avoided. So it's really a difficult balancing act between being able to evidence the ground that you're relying on without souring relations much further than they may already have been. Another question, if there are financial or children matters, is it better to delay applying for decree absolute? Charlotte, I don't know whether you might want to take this question because it follows on from the last point that you raised.
I think it depends what the financial matters are, but as I said, if they are matters that could have a nexus on the amount that a client can receive in settlements, if there are trust fund issues, tax issues, pensions issues, then it's definitely better if your client is the one who's going to benefit from those to delay applying for the decree absolute. And you could equally find yourself in a situation where actually you want the absolute granted to safeguard your client's interests. However, in financial proceedings, the courts will have views on conduct that perhaps maybe the decree absolute has been done to try and bar the other party unfairly from assets. So you do have to be careful both ways with the decree absolute. In terms of children's matters, it's going to really come down to the facts of the case, but they are more likely to be more separate than the financial matters. The courts are unlikely to say that children's matters and the decree absolute are as closely bound, but it's really going to come down to the facts of the case that you're dealing with.
Yeah. There's a question here, how can a party insist that financial matters are resolved before decree absolute is pronounced? And what I will say is there is always scope for the parties to be able to resolve and agree their financial matters amongst themselves without the need for issuing financial remedy proceedings. And in a lot of cases, it may actually be possible to agree a consent order or just to agree it without having to start proceedings, certainly where there is the scope for a divorce not to be a contested divorce. That will certainly save all of the parties a lot of time, a lot of money and a lot of upset. So that would certainly be the first port of call to trying to resolve financial matters. How can a party insist? Well, it becomes quite difficult if another party is not willing to resolve matters or the parties aren't able to settle matters, either amongst themselves or with the help of a mediator or other assistance. Well, then I think you are really looking at financial remedy proceedings as the only way to resolve that issue.
Mm. Can you make a financial application after the decree absolute has been granted? Yes, you can. They're separate proceedings. When is no fault divorce likely to be brought in? Well, in Owens and Owens, the Supreme Court were as critical as they can be, really, of the government for having not done so. I think that was a 2019 case. I think it's something that's on their to-do list. I'm not aware, however, of any imminent legislation. I don't know if you are, Sharon, about no-fault divorces.
There's a question here about collaborative law when one party is resisting mediation. Well, mediation is only really beneficial when both parties are willing to engage and cooperate in it. It's the very inherent nature of mediation that it only works when both parties are willing to give themselves to the process. So I think it's definitely worth trying. I think it's definitely worth giving a very good solid go at trying to mediate matters and resolve matters outside of court, particularly where there's not a very big pot of money, because otherwise that pot is just going to disappear along the course of the financial remedy proceedings in solicitors' fees and otherwise. So that about brings us to our 30 minutes that we were promising we would get everything done by. I don't know if there's any other questions, Charlotte, you wanted to address just before we bring everything to a close.
No, we will be sending out a handout, so hopefully that will cover any unanswered questions that still remain.